Human advancement can be measured in technological progress. Since the start of the digital economy, we've been creating the right conditions for innovation to thrive and deliver positive change. By creating policy, regulatory and legal frameworks that keep things stable, predictable, fair and scalable. And these pathways we create drive economic growth and build better societies. Behind the breakthroughs and ahead of the curve, Access Partnership is playing a critical role in a critical space at a critical time.
All right, I think we are live. Let's kick off. Good afternoon, everyone. My name is Megan Shalapa, and I am Policy Counsel at Access Partnership, the world's preeminent technology policy consulting firm. We're really excited to host this webinar today in partnership with Workday. So today we're talking about AI, a topic, as we know, that shows no signs of slowing down. Here in the US, there's a lot of activity at the federal level, which is generally what dominates the headlines. We have the White House's executive order that President Biden is speaking about later today. This fall, we've had Senator Schumer's AI Insight forums that have really galvanized attention as well. But for this discussion, we're going to focus on activity that's happening at the state level in the US. So to kind of set the scene, an analysis prepared by BSA, the Software Alliance, found that so far in 2023, 190 bills that are AI related have been introduced so far this year, which is more than were filed in the previous 2 years combined. So to introduce an even bigger number, that is a 440% increase of AI related bills that we've seen more of compared to the prior calendar year. So to kick us off for this important discussion, I'm so honored and excited to introduce California State Assembly member Rebecca Bauer-Cahan, author of AB 331, the Automated Decision Systems Bill. So Assembly member Rebecca Bauer-Cahan was first elected to represent Assembly District 16 in California State Assembly in 2018. She's an accomplished attorney, environmental advocate, community volunteer, law professor, and mother. And as I mentioned earlier, she introduced, in January 2023, she introduced AB 331, a historic bill that we're gonna hear more about today. And we know that California is an incredibly important player in the tech policy space. So Assembly member, thank you so much for taking the time out of your busy schedule to join us this afternoon.
Thank you, Megan, and thanks to Workday and Access Partnership for convening this conversation. It's so important.
Great. Go ahead, sorry.
You want me to go ahead and make some remarks or tell me what to do?
Yeah, let's go ahead and get into AB 331. Can you tell us why you introduced it, how it addresses algorithmic discrimination, a little bit of background?
Awesome. Well, thanks again. So you heard a little bit about me. I am a child of Silicon Valley. I grew up in California, born and raised. I came back east for about a decade to go to college and law school, but went home to California and represent part of the Bay Area, the East Bay. Actually represented Workday for many years, although they got districted out of my district, although many of the employees are my constituents. And as you said, prior to becoming an attorney or prior to becoming a representative, I was an attorney and practiced in the intellectual property space. So I think this is an incredibly important conversation to be having as it relates to how we update our laws as technology innovates. And, you know, we know today that AI is making 50% of the decisions that affect our lives every day. So people often say that I'm, you know, ahead of the curve. I actually think government is behind as it relates to regulating these decision tools. And innovation is critically important. And AI has amazing beneficial implications, such as helping combat climate change. We see AI being used in my district on tractors to better use water and pesticides. There are amazing ways that these tools are being used, but we also know that it's our job as government to ensure that all things that enter our society are done so responsibly. And so AB 331 really focused on the management and testing of the AI tools that are being used to make decisions for us. And we know that they can have devastating impacts if they're not done responsibly. And we know that our vulnerable communities will be the first to receive the blowback if these tools are not built in a responsible manner, that the data inputs are not representative, and all the things that we should be thinking about as we move forward in smart AI. So AB 331 was really focused on protecting individuals from algorithmic discrimination. It requires developers to end users, so both developers and deployers, to mitigate and assess the automated decision tools that make these consequential decisions. It was really kicked off by the president's AI Bill of Rights, which he unveiled last October, really started getting the nation thinking about what does it mean to protect our communities from these tools, while also allowing them to be valuable things that make decisions for us every day. And so that's, it's very broad reaching. It focuses on what we think is every consequential decision being made by artificial intelligence, from healthcare to employment to housing, to the decisions that are made in our courts every day, and ensuring that they go through the proper testing to ensure they aren't being deployed with discrimination built into them. And we think this is critical for equity and to help our marginalized communities as AI becomes even more ingrained in the decisions that are being made in our communities.
That's so interesting. And I want to touch on a point you made about testing. Can you talk a bit about AB 331's focus on impact assessments as a tool for accountability? Why impact assessments, and why do you think they're important?
Well, I think it's also, one of the things that makes California, I think, poised to lead in this policy area is our relationship with the companies that are building these tools. A huge part of this market is in California, and we were in relationship with the people who are creating these tools and doing this work every day. And so part of what we did when we started thinking about this and working on this was listen to those partners. Find the responsible players. What are you doing? How are you doing this? How are you protecting communities? And we really started to learn that impact assessments were one of the best in class tools, and people are doing it voluntarily, right? The good actors are out there ensuring they're not deploying discriminatory tools, but we know not everyone's doing that. And so part of it is by using the tools that are already in the market, I think it's going to help innovation, but also I think it's a critical tool to ensuring that we don't deploy discriminatory tools, right? If you're looking at that impact assessment, if you're looking at the impact of the tool that you're putting out into the market and making sure before deployment that it's non-discriminatory, I think we will be better off. And it's actually incredibly exciting. So if you think about our civil rights laws today, we only get to correct things after wrongs have been committed. And the opportunity here to do these front-end impact assessments will ensure that we can prevent discrimination and not just make up for the wrongs that have already been committed.
Yeah, that's a really key takeaway. One of the things that distinguishes this bill from other AI-related legislation, as you mentioned, is this developer-deployer distinction. Can you talk a bit about that and how the impact assessments are maybe addressed differently in both of those situations?
Yeah, we're fully aware that one might develop a tool and they might give it to a customer or another entity, and they may change that tool, right? And the developer intended it for one purpose, they built it, they may have done their impact assessments and ensured that it would be deployed in a non-discriminatory fashion, and then changes happened. And so what we want to make sure is that every part of this chain is being responsible. So if you, the developer, create a tool for a certain purpose, you test it, you hand it off to a deployer. If the deployer makes significant changes, it is on them to then do another impact assessment for the way they intend to use the tool. And that's a really critical piece of this, because we want people to be responsible for the work they're doing. And I think that really helps innovation, because it doesn't make you fearful of all the possible outcomes. You're responsible for the outcomes you intend. And if someone else shifts it, then they're the responsible party. Yeah,
piggybacking off of that, I think one of the things that you've said and that we always hear about AI legislation is that AI regulation needs to be forward thinking because just of how the fast-paced nature of how the technology develops. And yeah, you said it right there, that impact assessments are a way to, balance responsible AI development and promote innovation. What have you heard from, and others in your community about, or any of the stakeholders you've been talking to about how to do just that, how to balance responsible AI development with innovation?
I think it is what everybody wants. It's really hard for us. I'm going to own it. It's hard for us to get policy right, to hit that perfect balance. We're doing our best. And part of that is the learning I talked about. But it's really important. And, I come out of big law, right? I was a woman in big law. I know that there are industries out there today, as we talk about AI decision making and hiring where people who look like me are at a disadvantage when a human is making that decision, right? Because we have bias as well, right? It's not just these automated tools. And so I believe so deeply in these tools because I think they can actually make it better, right? For people of color, for women, that we can create tools that have less bias than humans do. We are not perfect. So if we can, improve upon decisions that are being made today, then we are moving the ball forward for society. So innovation is critical because these tools really are helpful. But to your point, we have to balance that with regulation. And how do we do that perfectly? Again, I'm not going to feign to say I'm going to get it exactly right, but I'm going to do my best. And part of that is also making sure the law is nimble enough, that it allows for the continued innovation and change. I was just on a panel at the Chamber of Commerce last week where one of my colleagues was really focused on the definition of AI. And I think the important part of AB 331 is that it doesn't matter how you define AI. It matters the impact you're having on society, right? Because AI is going to change. I don't think we can come up with a definition of AI that will work because it's not static, what it does, how it works. But what we can look at is how are we using these tools to impact society, and that's where our focus should be.
That's really great. On that point, we talk obviously a lot about regulatory guardrails, the risks, the AI doomsday scenarios. You mentioned climate change. You mentioned, lifting up marginalized communities. But one is, as a daughter of Silicon Valley, what is one of the use cases of AI that you've seen that you're really excited about?
Oh gosh, there's so many. I often talk about the radiology, right? I get my annual mammogram, and the idea that we're helping doctors read those tools better, right? We're not displacing those doctors, but we're making them better and stronger using technology. And we could prevent more instances of, aggressive cancers by detecting them sooner, for example, I think is incredibly exciting. I talked about employment. I actually think we can make the employment market more equitable using these tools, and that's incredibly exciting. Climate change, though, might be top of my list because I do think it is the existential threat that's out there, and I see the way these tools could be used to predict and help us solve what are the most complex problems that society is facing.
Really, really important stuff that you're working on. I want to thank you so much for taking the time out of your busy schedule to join us this afternoon. Assemblymember Rebecca Bauer-Kane, thanks so much.
Thanks so much for having me.
So now we will switch to our panel, and I think my panelists are going to be trickling in shortly. Awesome. I think we have everyone. All right, so we have a lot to talk about, so I'm going to introduce these folks quickly, and then we'll dive right in. So we have Amber Ezel, Policy Counsel at Future Privacy Forum. We have Russ Hanser, Associate Administrator for Policy Analysis and Development at NTIA. We have Matt Lenz, Senior Director of State Advocacy at BSA, the Software Alliance. And last but not least, we have Evangelos Razis, Senior Public Policy Manager at Workday. Thank you all so much for taking the time to join me today. So to kick things off, Matt, you heard me plug BSA earlier. That stat, about 190 AI-related bills that have been introduced this year. BSA recently released a position paper on legislative trends in 2023. In that report, what are the trends at the state level that you're seeing, and what does the landscape look like as state level AI activity ramps up?
Yeah, awesome. So first off, thank you for this opportunity to speak with you all today. And I just have to acknowledge the Assembly member and the great work that she's doing in California. She's been, a really great person to work with. BSA has been working with her as well as others, and it's been a great way to develop policy. And look forward to continuing to work with her. When it comes to AI, I think we wake up. At least I do. I wake up every single day and I see something new on AI. Today we woke up and we have that executive order coming out, right? And that's going to have ramifications at the state level. There's going to be ideas in that executive order that are going to filter their way down to the states, and we'll have to wait and see what that looks like. But it's certainly something that we're keeping a close eye on. But states have really been at the forefront of AI. It's been well in front of Congress at this point on some of the activity that they're doing. When you look at what we analyze, that 440% increase in AI bills, that's including things such as specific AI use cases, governance frameworks, law enforcement use of AI tools, task force and committees, state government use of AI. So the breadth of it is pretty expansive. But I think I will say that for the most part, a lot of these bills, the ones that have at least passed and became law, have really been focused on study groups and different task force that states are realizing that they need to take a look at what they're using currently, what the different areas of concern are going to be. So you have about 20 states that have, dedicated task force or work groups that are studying AI as an emerging technology. And then you also have third-party groups that, we're really starting to see bring folks together to look at model legislation or develop model legislation. So, the National Conference of State Legislatures, Council of State Governments, National Association of Counties, the National Governors Association. Almost every time I go to one of these conferences, there is a panel on AI. It is the topic of concern at the moment. And then I've also seen legislators coming up with their own interstate work groups, which is something I've just never seen before. So you look at Senator Maroney in Connecticut, who's brought together 100 legislators from across 30 states to discuss AI policy and AI trends. And it's just something you've never seen, at least I haven't, at the state level. So it's vast. It's moving quickly. We expect that number of bills to increase into in 2024, and we're looking forward to really having some great conversations and policy developments at the state level.
That's great. I think also in that report, there's kind of like 6 major trends, and impact assessments are on that list. Evangelos, I spoke to the Assembly member about impact assessments. They're one of the top trends in the BSA report. How do effective governance programs incorporate impact assessments? And what is Workday doing in this space?
Yeah, great question, Megan. And first of all, thanks for having me and for hosting this conversation. And I just wanted to sort of add to what Matt had said about the Assembly member's leadership on these issues. I think she and has tapped into that tradition of California leading the way on a lot of AI regulation, tech regulation broadly, and really she's been a very thoughtful partner on many of these issues, including with AB 331. But to answer your question directly, when it comes to impact assessments, earlier this year we released a report with Access Partnership that Megan, you helped co-author, and I think it sort of explains why impact assessments are really the tool that folks are turning to. So one of the reasons why they're familiar to organizations. So many companies have to carry out impact assessments under state privacy laws, under GDPR and a lot of international privacy laws. So they're pretty familiar. They're practical because, as the executive order today seems to acknowledge that standards development is a key aspect of AI governance. And, at a time when technical standards are still maturing, we need to still find a way to assess AI tools, especially high-risk AI tools, for potential impacts, and impact assessments are a holistic way to do that. So they're practical. And then third, they're future-proof because they're holistic. You can add technical standards. You can take advantage of technical standards with time. You can add additional considerations with time. But again, there's sort of that first step needed to address concerns around impact assessments. In terms of how we're viewing AI governance and impact assessments, where they fall into that, impact assessments are really the accountability tool for high-risk AI systems. So, early on in our process within Workday, we assess whether a tool is high risk or medium risk, low risk, and sort of gets tracked accordingly. And those high-risk tools get assessed for their potential impacts, especially when it comes to concerns around bias. So we think about this in terms of consequential decisions. If a tool can implicate a consequential decision, which we define as, for example, as hiring or pay or promotion, that's a high-risk tool and is going to be assessed accordingly. One of the reasons why we like AB 331 is it is a holistic approach. So, we're oftentimes Workday is an AI developer, but At the same time, there are deployers, our customers, who are using these tools as well. And so I think the AB 331 is, again, that sort of comprehensive framework because it gets both developers and deployers.
Yeah, I want to switch to the workplace context as we're discussing impact assessments. Another report from one of our esteemed panelists I want to plug is the Future Privacy Forum recently released best practices for AI and workplace assessment technologies. So Amber, when we're talking about impact assessments in the workplace context, what have you seen? And in the report, why do you think we need AI, impact assessments and safeguards and hiring and employment practices? Big question.
Yeah, huge question. Thanks for having me, Megan. Really have enjoyed being on this panel so far. Really, I guess to underscore what the Assembly member mentioned in her remarks, although AI has been being used for a wide variety of tasks right now, I mean, I think top of mind for a lot of folks, particularly generative AI, and then also improving product and user experience. One of the reasons why it's so important to focus on AI in hiring is because employment is one of those applications that really matters the most in people's lives. And we know that like upwards of like 70% and like probably growing at this point, percent of employers are using AI in their hiring processes. And so, this is something that is a really real application that impacts almost everybody in some way. And so just because of the consequential impact of the application of AI in that process, it directly impacts someone's socioeconomic status, for example. And so it's really important for us to get it right when it comes to the use of AI tools in HR applications. And so, one of the things that we really want to address in the report is how the use of AI has consequential impacts on recruiting, hiring, promotion, and termination. And so, as developers and deployers are, developing these tools, but also as they're being implemented by, employers as well, it's important that the use and the application of these tools is effective and fair and fit for purpose. And so it wasn't just us that was involved in the development of this. We developed in conjunction with Workday, ADP, LinkedIn, and Indeed. So Evangelos was on that team of us that was laboring away for the past year, trying to really put out these thoughtful best practices. And so one of the aims that we really wanted to look at and I think is going to be, top of mind for, not just all of us here, but also within federal and state agencies as well, especially in light of what we're expecting to see from the executive order later today, is that hiring and, AI applications to worker surveillance and also just employment decision making. That's top priority for the administration and also state and local governments as well. And so definitely not the end, not the end of the road for this. It's really just the beginning. But yeah, one of the things that we really wanted to think a lot about in developing these best practices is, testing for bias, mitigating potential discrimination, and then also safeguarding personal data. So it's refreshing to see that those are all things that are addressed within this executive order as well.
Yeah, Amber, one of the things I think is interesting, not just about, the best practices that FPF put out, as well as AB 331, is this developer deployer distinction. And we heard the Assembly member talk about that at the top. So this question is for Amber, for anyone. But when we talk about impact assessments and, the obligations that developers and deployers have, what obligations should they have when they conduct impact assessments? How are they different? And why does that difference matter?
Yeah, no, that's a really good question. So, particularly in the employment context, or any application that has, a high risk nature to it, it's important that in the employment context in particular, that job seekers and employees are made aware when they're being assessed or evaluated using these tools. So there's a transparency piece of that as well. But it really does, also fall on not just, developers, because, we talk a lot about developers and the way that these tools are trained. But, both developers and deployers are both uniquely situated to be able to explain to consumers or to users of these technologies how they work, how they're trained, some of the limitations. And then deployers, on the other hand, they can explain kind of more of the implementation and how the tools fit into larger decision-making processes. And so within our document, one of the things that we address is specific disclosures that developers and employers should make when they're using AI tools that have a consequential impact. And so, like, for example, being able to communicate, what are the intended purposes of these tools? Like, just because this tool is novel and, useful doesn't necessarily mean that it should be applied in every use case. How the tools are trained and even some of the limitations of it. And then, obviously just top of mind for all of us with regard to impact assessments is also whether these tools are being trained and assessed for potential discriminatory impacts. And so those are just like some of the things that are really top of mind, and just how it takes a lot of work on the front end to do all of these things. And because, just the opaque nature of these tools, it is kind of hard sometimes to communicate how these tools are actually reaching the decisions that they are. And so, yes, it takes a lot on the front end, but, I think the dividends that it'll pay are really great when we can really make sure that we're using these tools in a responsible and a thoughtful way.
Definitely. I don't know if anyone else wanted to talk a bit about developer or deployer. I think Matt.
Yeah, I think there's for me, having like an example is a great way to understand things. So if you think of it as a bank, right? A developer can create and train AI systems to make loan determinations. They can make sure that the training data is representative of the population. But the bank using the system, they're going to know how it works in practice. So the bank can review the data to see if the system is disproportionately denying loans to certain kinds of applications. So both the developer and the bank should have different obligations to take actions to mitigate the risk of bias because they do different things. And I think that's one way that you can think about how that developer and deployer can mitigate risks based on the different things that they do.
Yeah, that's a great example. Thank you. I want to bring in Russ here because we have of course, some important news out of the White House today. But Amber mentioned that the FPF principles, the best practices that they put out, those kind of stem from and fit into what federal and state agencies are looking into. We know that NTIA is taking an active role in developing policy recommendations for AI accountability. I think I saw that from the April RFC, you received 1,400 plus comments. So, not to put you on the spot to talk about 1,400 comments, but what has the agency learned from these comments about AI accountability?
Yeah, well, I just finished reading the 1399th one, so there's one still that I haven't read, but I'm going to try to make do. So first, thank you for having me. I'm really glad to be here, especially because unlike everyone else here, I do not have yet a published report. We are working on this report, but we can't talk about the published report because that's still a little bit in the offing, hopefully not that far in the offing. So as you mentioned, Megan, we issued in April a request for comment on AI accountability measures, including audits and performance assessments, and looking into many of the ideas that this panel and the Assembly member have been talking about. And our goal is to produce a report that will try to advance the ball on how to build a robust accountability ecosystem and potentially recommend policy. I should say that although we are government, we do not have the authority to issue rules and regulations, much less to adopt laws. So our power is in the power to convene stakeholders, get their views, synthesize them, see where there's agreement, where there's disagreement, and make recommendations to people who are empowered to write the laws and make the rules. We spent a lot of time going through the record, and a lot of what we have seen has resonance for things that have been said here already. So, point one, to go back to the point you were just discussing with Amber, the idea that transparency mandates or transparency burdens should be borne by the entities that are in the best position to know the information and best position to communicate that information to downstream, whether that's to another business customer or to an end user consumer or whatnot. So there are obligations that will apply to different entities, maybe at different points in the AI system lifecycle, or maybe throughout the life cycle, different obligations will apply to developers versus deployers, and there may even be other relevant categories. I think another point which has come up in this conversation, which is in accord with what we've seen in our record, is that different kinds of AI systems pose different levels of risk and may warrant different levels of scrutiny. Some might. I'm not making news about the report. I couldn't tell you what's in the report because it still hasn't been published, and everything in it right now could change. But the record suggests at least that some kinds of AI systems might appropriately be subject to mandatory assessments, whether those are performance assessments, formal audits, or other assessments, whereas others might not be. There may be a call for third-party assessments in some areas, subject to particular standards and criteria for reviewers and auditors and so forth that might not apply elsewhere. And then another theme, certainly, and this is consistent with what we've heard in this conversation, consistent with the EU AI Act and so on, is that the use cases the potential use cases are going to determine the level of danger. And one thing that interests me personally is the distinction between the intended use case and what I've called the reasonably foreseeable use case. I joked to someone recently that no car manufacturer intends a use case in which the car collides with another car, but that happens, right? And as a result, we install safety mechanisms, even if they're not the intended use case, because those are reasonably foreseeable use cases. The type of use case involved is going to help govern what kind of accountability we want to what kind of accountability obligations or burdens or prescriptions we want to apply. I'll also just note our report is going to address, or at least if it is released in something like the form it is in now, it will address not only kind of these questions, but then some other questions about how do you build an accountability ecosystem? How do you make sure there are a pool of potential auditors or assessors? How do we move toward a world in which red teaming and assessment and audits are available to the extent that we think that they're necessary? Because that's a question that's a relevant policy question as well. And I don't know the exact statistic, but we've all heard some version of 80% of the jobs that people will have in 30 years have not been invented yet, or have not been named yet, identified yet. One of those classes of jobs is going to be AI auditor or AI assessor or drafter of the criteria for AI assessments. And if we're looking ahead to sort of build those ecosystems, we want to think about what the inputs to that will need to be.
Thanks for sharing.
Sure.
To the point. Oh, sorry.
Nope.
Oh, okay. So the point about impact assessments versus audits, I wanted to ask if can't share the contents of the report, but are there certain situations or use cases where you could see a recommendation to use an impact assessment versus an audit, because they're two very different types of accountability mechanisms?
Yeah, it's an interesting question. And as you say, repeating back to me, I can't tell you for sure what's going to be in the report as published. I will say that as a general matter, we try not to be too prescriptive in distinguishing what kind of accountability mechanism is applied in a particular case. We refer to these generally as accountability inputs in the report, in the draft report. And we talk about both. Again, we're making recommendations to policymakers, and different policymakers will come at this from different perspectives. So we paint in somewhat broader strokes on those distinctions, but here and there may be specific ideas about which one of those is appropriate and what that means, what it means to be a performance assessment versus to be an audit.
Got it. Before we get to, I want to do a little bit of forecasting as we, are looking into 2024. But I did want to see if anyone else wanted to, have any other points as we were finishing up the developer deployer conversation, or what that means for impact assessments. Evangelos, I see you nodding, so I'll let you go.
Yeah, happy to add a few thoughts. I think the OECD has a pretty helpful sort of distinction here, which I think feeds into the developer deployer distinction. So when we're thinking about AI governance, AI risk management, there's often talked about the need to have a life cycle approach. And so the developer is the one that can see sort of how an AI operates in the lab. And so, we can use certain data under sort of certain controlled conditions to try to address some of those reasonably foreseeable risks that Russ had mentioned. That sort of work, especially for high risk tools, making consequential decisions, that must be done. But at the same time, when it comes to deployer, they're the ones using the AI tool in the field, and that's the language the OECD uses. And I think it's pretty helpful because that is being used in real world conditions and needs to be tested in those real world conditions for potentially discriminatory impacts. So I think that's pretty helpful. I would also just to point folks back to the impact assessment report released earlier this year, because I think it really kind of delves into some of the trade-offs between an impact assessment and a third-party audit. For us, we have cybersecurity audits, for example, using third parties because we use that to communicate the trustworthiness and rigor of our cyber programs to our customers. I think there's some necessary preconditions to get in place first around third-party auditing to deal with things like conflicts of interest. What is how do you prevent against malfeasance from potential auditors? How do you have commonly accepted standards so that we're all sort of auditing against a sort of common baseline? I think a lot of those questions have not been figured out. I think we're active in those discussions because we think in the longer term, third-party auditing has a place in the AI accountability ecosystem. But I think for now, we're thinking about what are the regulatory safeguards that can be put in today, as opposed to what are the safeguards that we can put in place tomorrow when some of those preconditions are there.
Right. As you said, to continually future-proof how we're thinking about AI regulations and safeguards. So before we get into forecasting, I did want to make an announcement to our audience members that if you have any questions, to pop them in the chat, and we will get to them. Just wanted to let folks know about that option because we'd love to hear what folks are thinking about as we have this discussion. But more broadly, I think we talked about a lot of really important topics today related to accountability and how to prevent bias and discrimination, what the AI development life cycle looks like, and to bring it back to the state level context. We're approaching end of the year. We're seeing a lot of AI policy in 2023 roundups and predictions for 2024. But this is a broad question for everyone. As we think about state laws and proposed legislation, what do you think we can expect in 2024 and beyond? So I want to go first.
I'll take first shot at that, Megan. I think it's funny you mentioned the we're seeing the 2023 roundups, but I'll say in the past 2 weeks I saw 14 bills filed in New York all related to AI legislation. So preparing for 2024. So it's as we're trying to do roundups, we're already seeing pre-files for next year or drafts for pre-files. I think we're going to see a variety of different things. I expect AB 331 when that gets refiled. I believe that's the Assembly members' intent there. We're going to see that be a big player. And I think we're going to see some copycats of that too in other states. I already know that there's some interest in a few other states to go along that same type of path on AI. But I also think we're going to see it in different related contexts of, deep fakes is a concern for folks. AI and its use in election campaign ads has been a focus. I think we're going to see it, in law enforcement use, how government and procurement rules are working, and would really urge folks to take a look at the NIST framework as a possible path with that. So, I think we're going to see, I fully expect to see hundreds of AI bills at the state level next year. We'll see which ones take up the oxygen in the room. Not all of them are going to get the same attention, but I certainly think it's going to be a prominent role in the legislature in all 50 states next year.
Definitely. Oh, Russ, I think you're muted.
Sorry about that. I was going to say, I don't bill myself as a state legislative expert by any means, but I think generally the hockey stick is still curving up here, consistent with what Matt said. I think the numbers are likely to be higher. I think 2023 was a year in which we transitioned a little bit from principles and, very high level, everyone coming out with their 10 precepts, et cetera, toward like, okay, but what does this mean for governance? And I think we're going to see a lot more reaching toward that at both the state and the federal level. This is not prognostication because the fact sheet is out regarding the executive order, even the order itself is not, but the fact sheet is out. You're going to see a lot of activity across the executive branch, especially. And there's some recommended items for independent agencies in there. They're not subject to the executive order, but there can be recommendations. So I think you're going to see just a lot of attention across the federal government for sure. And then I'm also not a Capitol Hill person, but I think we'll start seeing some of the roundtables and discussions, turning into draft legislation there. So I just think whatever this year was, we all thought this year was, insane in terms of turning on the news every day. I think next year is going to be more, but more.
Point.
Yeah, if I can, weigh in here too. I would echo what Matt said about just the sheer volume of AI legislation that we could anticipate in 2024. One of the things that I think we'll see a lot of is a more sectoral approach to AI legislation. I think, a lot of folks tried their hand this year at trying to put out some comprehensive AI legislation. But I think what we're going to see a lot more of is, a more specific approach, like looking at, elections, for example, looking at employment, looking at credit, lending, all of the like, and really trying to push forward AI legislation in that way, because I think it's a lot easier. It's a lot easier lift to try to deal at specific issues rather than trying to come up with a generally agreed framework of what AI legislation should look like. So I think that, I think if your head was spinning this year trying to keep up with all the AI legislation, I think that we're in for a whirlwind next year as well. So I'm really excited. I think, like, even outside of the states, we're going to see a lot coming out of the federal government as well. Like several agencies. Well, I guess with the executive order, AI is probably going to be top of mind for all agencies. But we even saw this year that several agencies have made how they deal with AI a top priority for them moving forward. Like the FTC, DOJ, CFPB, and EEOC, for example, have made direct statements about how they see AI legislation or AI regulation in the grand scheme of their authority. And so we're going to see a lot more coming out of the federal government as well. I know we're talking about the states, but definitely going to be a lot to track in 2024.
No, I think it's very important. Yeah, Matt, go ahead.
And if I could just add on that, I think I agree that we will see a lot on the federal side too. I think specifically from the agencies, I do think Congress will be taking a look at legislation. I think they already are. I will just highlight, though, at the same time where Congress has taken a look at comprehensive consumer data privacy for years, it's never happened at the federal level yet. Whereas at the state level, there's been 13 states so far. So I would just urge folks to really keep an eye on the states because they've been leading on tech regulation. where you need legislation to do it. So certainly don't forget about the states when you're looking at AI next year.
I guess I'll round us out. And although I think, Matt, you may have stolen a little bit of my thunder. Look, I think there's been a lot of thoughtful discussion on the Hill, hat tip to Majority Leader Schumer and as well as several of his counterparts in the House and Senate. I think there's going to be an influx of very thoughtful regulatory proposals on Capitol Hill. But as we've seen in the privacy set of discussions, it can be very difficult to get a law passed. I don't think that's news to anyone who watches Congress. And so I think we're going to see leaders like the Assembly member really driving the conversation. I think it's appropriate to have this conversation the day of the executive order, given that I think in our view, AB 331 is definitely one of those more cutting edge, forward-thinking bills we've seen at the state level, and is very promising as setting a benchmark for other states. So I think, like many, we're keeping an eye on different proposals and the sheer quantity of proposals, but at the same time, I think we're looking at how do we get at a concrete level these safeguards right. I think that's one of the reasons why we keep going back to AB 331 as one of those benchmarks. I think we're going to see similar bills like it come in other states. So I think in that case, we're pretty excited for the coming year.
Definitely. We have gotten some questions from the chat, so I want to pose these to the group and see what you all think. There, to Amber's point about the sector-specific pieces of AI legislation, there's a question about healthcare and one about copyrights. Yes, when AI is used in healthcare, how can protected health information, or PHI, be utilized responsibly, if at all? I don't know if anyone wants to take a stab at that.
I mean, certainly there's already some laws on the books to protect personal health information. Yep. But I also think this brings it back to the broader point that just because AI is the hot topic right now, don't forget about comprehensive consumer data privacy. It's such an important thing that states can look at what other states have already passed, and there are great laws to protect consumers' data, not just in healthcare, but in other areas of consumer data privacy. So we think that states should do both. I mean, I really take a look at consumer data health privacy, and BSA is here as a resource. I know the Future of Privacy Forum is too, and others. So can't forget about that aspect as well.
Yeah, and I will double click on that. So at the federal level, our view is that federal data privacy legislation remains essential. It remains the right time to adopt such legislation, and that such legislation is a critical part of AI accountability policy. And to the questioner's broader point, I can't speak to the what should be done question exactly, but I will say it points to the question, how can protected health information be utilized responsibly, if at all, just gets right at the heart of the role data plays in training AI models, and the potential tension, I should say, between privacy and getting the most informed models. And that's a needle that needs to be threaded. We want our models to be accurate and good, and we want them to be accurate and effective, but we also want to maintain privacy protections and not be misusing data that is confidential for a good reason. So I think that points right to that tension and why privacy policy and AI policy have to go hand in hand.
Yeah, and to the point I think about healthcare as well is that, Amber made this point about different executive agencies will be, active next year. I mean, we obviously have HIPAA, one of the few privacy legislations that we do have, but the FDA is incredibly active on, putting out rules and regulations for AI in medical devices. So I think, we're going to see a lot more of that next year as well. I think we have another question about the tensions we're discussing between AI and privacy. So yeah, Hill folks have said So this question from, Kristen. Hill folks have said that AI legislation won't be considered in Congress until there's a federal privacy law in the US. That seems tough. Do you see that dynamic at the state level? I don't think so.
I'm happy to add some thoughts too. And I see it's from Kristen Jency, and it's a great question from her, unsurprisingly. And so I think in short, I agree with you, Megan. No, I think we've, states have shown that they're willing to lead the way on privacy and not wait for DC. And I think that dynamic is sort of just happening at an even faster clip when it comes to AI issues. And so I think there's a wide acknowledgement that privacy is sort of foundational to good AI governance. I think that's something that we agree with. I know there's been a lot of discussion around non-discrimination, appropriately so, but another very important consideration when it comes to AI governance is privacy and data protection. And so I think in some cases, maybe we'll even see bills that try to advance both aims. But in short, I don't see that being much of a hang-up for a lot of state lawmakers.
Yeah, I mean, what do folks think about, not to, get into the privacy patchwork too much, but, we're probably going to see the same thing happen with AI, this patchwork of AI laws across the country. What are the concerns about that? Similar to privacy, or, as Evangelist mentioned, if they're tacked onto the privacy legislation, how does that, impact things?
I think there's always a concern about patchwork, right? Because, I think in a perfect world, one law to govern the 50 states and its municipalities is what everybody would like, right? One clear direction. But I think we have learned from the privacy debate, going back to that, that states can advance privacy in a way that is interoperable between the states and still provides great consumer protection. So, I think we've seen in the privacy debate where everybody's sort of, with little differences, have coalesced around a single model of comprehensive consumer data privacy, and that's worked. It's provided consumer protection for folks when the federal government was unable to act through Congress. So, my hope is that it goes in that direction, but there is also the fear, obviously, that you could have a large amount of rules that could conflict with each other. I will say, when talking to legislators, it just so happens that a lot of these legislators are some of the same folks that have been involved in the consumer data privacy laws in the various states, and they are very cognizant about trying to prevent onerous patchwork, and I think that's an encouraging sign.
Yeah. Great. Okay, I think we had another question. Kind of touched on it in like the executive agency sense, but what should be the regulations over AI regarding copyrights in many contexts, such as writers' productions, actors' performances, or even a simple resume cover letter? I don't know, in terms of, I was trying to think, the Patent and Trademark Office and Copyright Office will be putting out guidance later next year as well. So that's, more to watch at the federal level there. I don't know if anyone has any thoughts on, how to regulate copyright for artistic or creator purposes, but
obviously want to open it up to others, but that's been a fascinating topic, that something as a legal nerd that I've been just really interested in. I remember reading about the Copyright Office, and I don't have the exact case, but where somebody had used AI to come up with a comic book where they arranged it, but the drawings were not their own; they were AI created, and the agency said, you can't copyright the images because they're not made by a human, but you can copyright the way that you arrange them. So I just think that we're going to see a lot of development on that front. I think we're going to look to the federal government and the Copyright Office on that. But states do play in that arena on occasion. You've seen that with scholar athletes at colleges, the likeness provisions. So there's definitely something to keep an eye on at the state level. I know the actors guilds and screenwriters are very active on that front.
Yeah, I'll take a swing at it. First, on the previous question, I'll just say, I will give state lawmakers a lot more credit maybe than I think some folks are giving them. I think they understand the importance of interoperability. And I think we're already seeing that with some of the really positive steps being taken by folks like Senator Maroney from Connecticut to pull together lawmakers so they can have well-informed conversations with his peers across different states. So I think, again, to their credit, state lawmakers are considering interoperability as a key important policy objective, and I think that's the right approach. Second, without sort of opining specifically on IP issues, I'll just say, especially in the context of generative AI, when it comes to enterprises, I think making sure that you have appropriate IP protections, that you are, in addition to the normal sort of privacy and security protections, is key, because enterprises, if very much a different environment than sort of a direct B2C consumer, generative AI tool. And so key consideration, I think we're seeing from our customers, making sure that, whether it's IP or cyber protections or privacy protections, that they're being considered by developers. And that's a key issue when it comes to uptake of generative AI in the enterprise. So it's definitely it's definitely important.
I think we have time for one or two more questions. I have some for all of you, kind of one about the accountability side of things and one about the state level activities. So when we talk about, all the bills that are being proposed and enacted at the state level, they'll probably take a lot of resources, a lot of time. Do we think that policymakers and their teams at the state level have enough resources to, for these legislations when they go into effect? And what do we think is missing, if anything?
I can take a stab at it.
Yeah, go ahead.
So I would say, just in my conversations with lawmakers, that they don't necessarily have, a ton of resources. The resources are out there. Folks like Matt and myself, that this is what we do. We educate and really try to help lawmakers and companies and organizations really think about this in a really responsible way. And so I would say that the resources are out there. They just need to be tapped into. And so, I know that one of the things that we're doing at FPF is really trying to, put out more educational resources, and even for, not necessarily just lawmakers, but even for organizations as well that are really trying to grapple with how to, for example, like implement generative AI policies. We recently released a checklist on that, which you can find on our website. And so the tools are out there. I think that one of the biggest challenges, though, is like centralizing all of it, because there's, you hear so many different definitions of AI. You hear so many different definitions of what is an audit, what's an impact assessment. And so I would say that one of the biggest challenges that I'm seeing is like really just like a flood of information. And so that's one of the things that we're aiming at trying to do, is trying to consolidate these resources and really, make sure that we're more heavily utilized. And so I would say that the resources are definitely out there, but definitely should be tapped into more.
Yeah, and just to add on, Amber and myself, we're here. If there's any staff or legislators who are listening, please feel free to reach out to us. We want to be a resource, but also lean into to those third-party organizations like NCSL. Council of State Governments, National Government Association. I mean, those are places that are bringing together your colleagues to share ideas and exchange best practices. And I think in such a state constrained time period, it's important to lean on those. I'm a former state employee. I certainly understand the workload, and I'm sure it's the same too, Russ, at your level, where it's just you wish you had more resources. But don't try to reinvent the wheel, because the wheel might already be made, and you just need to go find it from your colleagues.
And this, I'll just add, if there's a minute there, this is also
Yeah.
a time for government at all levels to be staffing up on people who have the technical expertise, and the ability to sort of communicate technical expertise to policy expertise to ethics and connect all the dots. My office historically has interns sometimes throughout the year, but certainly over the summertime. And this, typically lawyers and policy folks are the interns. This year we had a PhD candidate in human robot interaction and a dual master's student who was studying AI and computer science. And they were immensely valuable. Those folks are valuable at all levels. And it is time. It probably has long been time, given the prominence of technology policy issues, to have that kind of expertise in-house. But if it hasn't been done yet, then this is a good time to start.
Yeah.
I guess I'll close this out. Look, I think a lot of folks, especially in DC, there's been talk around things like existential risk and the like. I think at Workday, we're very much focused on the risks of today and the potential risks that AI tools can have on individuals concretely. And so we're thinking a lot about this. We're working with partners like BSA, like FPF, to advance concrete, tangible, workable safeguards. And so we're here to help.
That's and Workday is a BSA member, but I will say, you want to talk to a company that's really thinking forward in the policy sector. That's a company to talk to.
Well, thank you all so much for taking the time. I think this was a really, timely discussion, obviously, and incredibly important to dive into a piece of, AI policy that I hope to see more discussions about in the coming year on, impact assessments and what's happening at the state level. So Amber, Evangelos, Russ, Matt, thank you so much, and have a great afternoon.
Thank you,
Thanks
Megan.
everyone
Thank you
for
for
joining.
Thank you.
Thank
Thank
This
you
was
all.
great.
Thank
Thanks
you.
for having us.
Take care.